Hello and welcome back to my channel Courts, and today once again I am before you to deal with or rather discuss with one important legal aspect. Anyone who wish to be a judge in a district court has to pass a competitive examination conducted by the judicial department of every state. So if you want to be a judge of a district judge of Maharashtra, then you will have to get through those examinations conducted by the judicial department over there. Similarly, if you want to be a district judge in the UP, then the relevant examination for the appointment of the district judge by the particular state, that is here in this case in UP. So in all state, concerned state conducts examination for appointment of the district judges. Of course, those examinations are under supervision of the concerned High Court as well. So here it was a peculiar case where a lawyer who is practicing in Delhi wanted to participate into an examination for the district judge, which is going to be conducted by the Telangana state. However, he was not allowed per se, rather he was not allowed to participate, and that is how he challenged that petition. He challenged under a petition before the Telangana High Court, which eventually did not grant him any relief. So the petitioner had no choice but to reach, or rather approach Supreme Court. The Supreme Court, in its interim direction, had granted the concerned candidate, who is the petitioner, to appear for the examination to be conducted by the Telangana state for the appointment of the district judge. You have to be very appreciate this entire judgment in the context that the lawyer who is practicing here in Delhi was refused, rather not allowed to participate in the examination. His application was rejected on the ground that he has no experience of practicing before the local court. Rather, he had not practiced in the local jurisdiction of the Telangana state. So his application for examination was eventually not allowed, or rather rejected, which had led to filing a writ petition before the Telangana High Court. And Telangana High Court wrongly, I must say it was wrongly, did not allow, rather granted any relief, and which led this candidate, the petitioner, in the who approached before the Supreme Court, and the matter was heard before the CGI's bench, and who eventually, after hearing the peculiar circumstances of the case and an issue involved, did not agree with the bar which was imposed, that a candidate, a lawyer who has no experience of practice in the local jurisdiction, cannot participate or rather appear for any examination to be appointed as a district judge. So that is how the issue was, and which eventually the Supreme Court, while hearing the petitioner's case in the peculiar circumstances, granted him the interim relief. And also the nature of relief which was prayed by the petitioner was in fact, by virtue of granting that interim relief, the petition itself got disposed of, with the relief being confirmed. So the point to be appreciated here is this: how one can, or rather one state can really bar a particular candidate who has no practice, who has not practiced into the local jurisdiction, from appearing for the examination of the judicial services, which is a bizarre and illogical bar. In fact, I have not heard of any such bar in my life. but eventually I really do not know, but whatever the examination eligibility criteria for the district judge appointment in Maharashtra, Madhya Pradesh, UP, and also here in Delhi, I have read and gone through. In fact, I appeared for one of the examination in the state of MP. My candidature, at least for the appearing for the examination, was never rejected, though I never practiced into the local jurisdiction of the Madhya Pradesh. Needless to say that I did have some experience of appearing in local courts of the Madhya Pradesh, but the predominant practice as such was not in the Madhya Pradesh. My practice is heavily and hugely into Bombay and Delhi. So that time my form or rather application to appear for that particular examination was not rejected on that ground, or rather that bar was not there as such imposed at that point of time. But however, in this particular case of Telangana, this bar was imposed, and the candidature of this lawyer who is practicing in Delhi came to be rejected, and that's how he had to approach to the High Court, who eventually did not grant him any relief, and eventually the Supreme Court had to intervene and granted him the relief, and now the candidate is going to appear in the examination whose last cutoff date was 17th of May. So within time, meticulously the petitions were heard and the relief were granted. That is how the disposal of the proceeding should be, and it's a welcome thing. I learned about this particular and peculiar case and thought of sharing with my viewers by uploading this video. That's how the intention of making this video. I hope you like this video, and I pray and I request you all to be connected with me through my channel on everyday basis, and also request you to bless me regularly on by watching, by viewing my channel. Till then, I can only request you all guys on everyday basis, but eventually it is up to you, and with your all support I can progress and I can make certain good videos on some good topics. So keep blessing me. Thank you very much for watching this video. I shall come back to you with another topic tomorrow. Till then, goodbye, have a nice day. And before I sign off, I again request you all guys to go and vote. It is your duty, it is our national duty, so do participate into the election and do participate into voting process. Cast your vote, whichever party, whichever candidate you like. Thank you very much. With this note, I am signing off. Thank you once again. Bye. Have a nice day.